for me, the first mistake that a lot of employers make is they fail to set their standards. It's up to employers to set the rules, whether it's on e-smoking or how to answer the phone or a dress code. So you've got to set the standard and then enforce it. There's no point in creating a rule and then just letting employees do what they want. That won't stand up in tribunal. Well, the second problem that employers make, usually because they're too busy, is that they ignore a problem and hope it will go away. We'll deal with it later. So-and-so's not coming into work very often, or they're coming in quite late, or their attitude is hard. And you go around ignoring this elephant in the room at your peril, because you can't come along later and then throw the book at somebody and say, but you did this a year ago, or you did that 6 months ago. That doesn't stand up in tribunal either. The flip side of ignoring the problem is going formal too soon. Most people make mistakes. Even I've made mistakes. I think it was 1977 I last made a mistake. But everybody makes mistakes. And most people, it's the attitude that you should be looking for. So it might be, if it's out of character, then some kind of informal coaching would be more appropriate than go down a formal route. Obviously, if it's very serious, then you go down a formal route. But most people, I think if you take them aside, if you explain, if you find out what's wrong, investigate, and then decide do you go formal or informal, that's a better thing to do. The mistake is you go straight to the formal route, and that doesn't stack up because you haven't considered the good behaviour that went on before the change. The fourth mistake that a lot of employers make is they don't follow a fair procedure. Statutory dismissal procedures apply in Northern Ireland to practically all dismissals and actions short of dismissal above a final warning. So you fail to follow a procedure, and indeed the LRA Code of Practice at your peril. Tribunals always look at procedures. They'll look at your procedures and they'll look at the LRA Code. So if you don't follow those, you're on a sticky wicket. Yes, another common problem that's come up very recently is overlooking employee representatives. The LRA Code is being revised on this point specifically. In general, it's up to the employee to choose who it is that they want to represent them at a tribunal, whether it's a trade union representative or whether it's a colleague. So make sure that they get the choice of their representative. And remember, breaches of the statutory procedures in the LRA Code of Practice could lead to a 50% uplift in any tribunal award, so be very careful.